Before a single word is spoken in this courtroom, it's important to understand just how serious this case really is. We're looking at a defendant with a long criminal history, facing a third or more DWI. Elevated Willy is a year after Willy. What makes this case unusual is that the defendant didn't get pulled over. He called 911 on himself. That single decision changes the tone of everything that follows. Was it accountability or desperation? Was it fear, faith, or simply damage control? Today's hearing forces the court to weigh years of criminal behavior against a claimed effort at redemption. There's a plea agreement in place, a 12-year cap, dismissed charges, and a judge who has clearly seen this situation many times before. The question is simple, but the answer isn't. When is it too late to change? Stay with us, because what unfolds in this courtroom is a powerful collision between addiction, accountability, and the limits of mercy under the law.
There's a gnat or a fly flying around. No, it was. Good morning, you're Norberto Armenta, and this is cause number 25 DCCR 0168. Mr. Armenta was previously in court, entered a plea of guilty to driving while intoxicated, third or more, in addition to pleading.
This moment right here is critical. The court confirms that this is DWI third or more, which legally escalates the case into felony territory. And even more importantly, the defendant has pled true to prior offenses. That removes any debate about past conduct for sentencing purposes. The 12-year cap means the judge has flexibility, but only up to that ceiling. It's also telling that the evading charge is dismissed as part of the plea deal, which already reflects a significant concession by the state. This isn't a question of guilt anymore. It's strictly about punishment. And when a judge says they've reviewed the pre-sentence report and defense materials, that's a signal they're about to balance the defendant's past against his claims of progress. From here on out, every word matters.
True to prior offenses, making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
I have. Are there any additions or corrections?
No, ma'am. No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start, as usual, with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case, and this is really an unusual fact situation in that he's the one that called 911 on himself in the vehicle because he was having I thought, and I'll let him explain it to you what the reasons that he did call and concerns. And as a result of that, received the DWI. The evading detention, Mr. Armenta, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip and he ultimately came to a stop. And he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over, and that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum.
This is one of the most emotionally charged parts of the hearing. The defendant openly admits he's been a criminal most of his life, describes relapse, addiction, faith, and most notably, taking responsibility without making excuses. Courts hear apologies all the time, but what stands out here is that even the prosecutor acknowledges this isn't the usual performance. Still, accountability doesn't erase danger. Driving under the influence, especially on cocaine and Xanax, isn't just self-destructive, it puts lives at risk. The judge has to weigh sincerity against statistics, personal growth against public safety. So here's the real question for viewers. Does honesty deserve leniency when the behavior itself is this dangerous, or is prison the only responsible outcome?
That day, so your thinking was not clear because you were under the influence
Yes.
of a lot of things in driving.
That's
So,
correct,
okay.
Your Honor. And I think that, he relapsed, I would say, because he has indicated, and I guess enough factually demonstrated that he is trying to maintain a sobriety through religious, faith-based rehab, or I'll say programming, but efforts to maintain his sobriety. The certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail, awaiting transfer over here. He does have a motion to revoke probation in Harris County for a
Sorry.
DWI that will be resolved after this case is disposed of. In the video side, again, relating to criminal history, there's some self-reporting that Mr. Armento did as far as gang affiliations. I want the court to know too that these are self-reported by Mr. Armento. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armento really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point to talk to the judge and let her know where you are.
Did she get my college degree?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good, and I relapsed. And Your Honor, I never dialed 911, and what they're teaching us is to take responsibility for your actions, and and that's one thing that I wanted to do is I wanted help, and I wanted to get locked up for a while and take classes, and that's what I've done before, and that's the only way I knew how to get help. And I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, and I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while for wrongs that I did, my mistakes, and I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would I'll have to deal with.
In the end, the court lands exactly where the law and reality intersect. Despite acknowledging the defendant's honesty and late-stage efforts at recovery, the judge makes it clear 5 years was never realistic. The criminal history is extensive, the risk to the public undeniable. The final sentence, 8 years in the Texas Department of Corrections, reflects both accountability and restraint, staying well below the 12-year cap while still delivering consequences. The firearm prohibition and waiver of appeal underscore the lasting impact of this conviction. This case is a sobering reminder that change is possible, but timing matters, and the law has limits on forgiveness. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
With me being an addict, and that's what I'm dealing with now.
Thank you.
Sorry.
Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. it's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court that way, so I'll defer to what he thinks is best.
So, Mr. Armenta, I make notes and go through the pre-sentence reports, obviously before court. I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous. I appreciate what you're trying to do now. Obviously, it's a little late, or a lot late, but it's, Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give something for what you are trying to do, but 5 years is not going to be it. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of driving while intoxicated, third or more. Find those prior offense true. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been. Ms. Holmes on Claudia Villalobos.
Thank you, Your Honor.
Yes, sir.